Good afternoon, everybody. I'm Asaf Ramarowski. I'm the Executive Director of SPME and ISMEA, and it's my pleasure to once again welcome you to our webinar series show. This afternoon, we have the privilege and opportunity to talk to Judge Roy Altman. Roy Altman is a federal judge in the great state of Florida, wrote a fantastic new book that details what a lot of the claims against the state of Israel, entitled Israel on Trial, Examining the History and Evidence and the Law. There is much to talk about. As many of you returning listeners know, we tackle a lot of these topics in many of our day jobs when it comes to the academy, a lot of the allegations when it comes to indigeneity, colonialism, apartheid, and whatnot. Roy here has done a phenomenal job from a legal standpoint, tackling all these topics. Some housekeeping matters. Roy will talk for a few minutes to give an intro and to open up the conversation. Then we'll come back and we will discuss a lot of the issues, and we'll open up to Q&A as always. Q&A will be done via the chat. All you have to do is type in your questions, and we'll do our best to get to them in a timely fashion. And if we don't, I apologize in advance. We'll do our best to respond after the show as well. So really, without further ado, Roy, thank you for joining us, and the virtual floor is now yours.
All right. Thanks, Asaf, for having me. I'm honored to be here. I guess I'll start by explaining a little bit about why I wrote the book. I should say I didn't write the book as a judge. I wrote the book as an American who loves this country and who came here when I was a little boy with my family from Venezuela, with very little, knowing no one. But we were always taught that if we worked hard and treated people with respect, that we could do or be anything, because the country was, above all else, a meritocratic society built on the rule of law. And I've devoted my life to that principle. And so that's why when I was 34 and the president of the United States saw fit to nominate me as a federal judge, people said, "You're crazy. You got your whole life ahead of you to make money, and you could do that later on." To me, it was a no-brainer because the opportunity to serve this community here in South Florida in particular, and this country more generally, that had opened its arms to us and given us every blessing and privilege that we enjoy, has in the last few years, as I've served in this capacity, been the great honor of my life, and I wouldn't trade it for anything. But then came October 7th, and it wasn't just the mutilation, the barbarism, the mass serial rape that was used as a weapon of war by the terrorists on that day. We've been used to Palestinian violence for a very long time, those of us who've been following the Middle East. It wasn't what was going on thousands of miles away. It was the reaction here in our sacred institutions, in our college campuses, like my alma maters, Columbia and Yale Law School, in our Western media outlets, in our international organizations that in many cases were created for the very purpose of ensuring that never again would Jewish victims have to see their tormentors and have no recourse. That those institutions, by and large, across large swaths of Western civilization and here in this country had come to love and be proud of, were falling apart and had turned the victim into the oppressor, had turned the tormented into the aggressor, had turned the violator of human rights into the Jew, the big bad proverbial Jew who's bloodthirsty and in particular lusts after the blood of infants and toddlers. Never mind the available evidence that on October 7th, 1,200 Jews were murdered. 100 or dozens of Jewish women and girls were raped, and 251 hostages, Jew and non-Jew alike, were taken into holes, deep, dark, den holes, hundreds of feet beneath the earth, and held there without food or medicine or sunlight for hundreds of days. And despite all that, we Jews became the violators of human rights. How could this be? This moral confusion that we see today in Nick Kristof's absurd and tragic New York Times piece, this moral perversion, this moral confusion in Western civilization, where does it come from? That's the quest that I undertook for myself right after October 7th. like so many people in the country, I thought to myself, what can I do to make this right? And I started traveling all over the country, been to almost all 50 states, to churches of every denomination and schools, colleges, law schools, and high schools across this country, trying to talk to people about Israel, its ancient past, its painful present, its hopes for a brighter future. And in the course of those many, many trips around the country, I got to meet federal judges all over America who themselves were curious about what was really going on the ground. And so I started a program to take federal judges, not Jewish. Most of them had never been to Israel before, from all across the United States to Israel. And I'm happy to say we've taken a bunch of trips since October 7th and taken almost 10% of the entire active federal judiciary in the United States. And there's now enough money in the foundation to return, to bring every federal judge in America, whoever wants to go forever. And then these federal judges would come back from our trips to Israel totally transformed. In fact, two of our judges sent their daughters to Israel for the summer in the middle of a war because they were so inspired by the culture and civilization they saw there. A civilization built on the same Judeo-Christian Western values of pluralism, religious tolerance, free expression, and the rule of law that had been bequeathed to us as citizens of a free and fair democracy for thousands of years. A civilization that's still willing, unlike so many Western societies, to fight and die and be resilient in its unity against the forces of barbarism and nihilism and extremism that seek to destroy us. And so these judges would come back from Israel and they'd start barnstorming their own states, their own churches, their own schools, their own local colleges, talking about what they saw. And it was inspiring to see them speak in their own language to their own people about what the truth really was. And out of that came a request from state Supreme Court justices all over the country who reached out to me and said, hey, what's up with that discrimination? You're taking federal judges. What about us? We're important too. And initially I said, I don't have time for you people, but over time they persisted and we've created a program to take state Supreme Court justices to Israel. And we're going to be taking our first trip now in October of this year, 20 state Supreme Court justices, and hopefully we'll take 20 state Supreme Court justices every fall until every state Supreme Court justice who wants to go has had an opportunity to see for themselves what the truth on the ground really looks like. And the point is that out of these thousands of conversations I've had with people all across this country the last 3 years on college and law school campuses, in churches and community centers of every denomination, I've come to recognize that the entire debate about Israel really boils down to 6 main claims about the Jewish state. And actually, when you pull back all the diatribe and the vitriol and the emotion, each of those claims is actually at its core a legal claim. And so I thought to myself, not as a judge, but as a person who knows and loves the law and is devoted to the law and believes above all else that the law has to form the baseline of that intimate relationship between a free people and its government in a free and fair society, that we should just apply that same legal methodology that judges, lawyers, and juries use every single day in courtrooms and law offices around this country. It's a time-tested methodology that we've been using for hundreds of years, a methodology we know we trust because we use it where truth-telling matters the most, in the courtroom, where someone's life is at stake, and then apply it to each of these 6 claims about Israel and see what happens. And so that's why the book is called Israel on Trial, because we put Israel on trial. And then each chapter gets a claim, 6 chapters, 6 claims. Each chapter applies the relevant methodology. It produces the facts and it issues a verdict one way or the other, not based on emotion, prejudice, or bias, but as you suggested, Asaf, in your introduction, based on reason and logic and common sense, the hallmarks of any fair and decent judicial system that's based on process and justice rather than emotion, prejudice, or vitriol, or anything else. And so, one of the critiques, I think fair critiques of the book that I've heard is, well, we shouldn't really put Israel on trial. People say Israel should be on the offensive, not the defensive. Maybe it's not fair to put Israel on trial. In particular, Israel, a teeny tiny country that is attacked in the international legal community more than I think any other country in the world. So you know that there's a Human Rights Commission at the United Nations or Human Rights Council that has a standing item on Israel. I think it's called Item 7. And so they've got a couple of resolutions against North Korea and a few against Iran and a few against maybe Russia. But they have hundreds, more than all the other countries combined, I think, or something close to it, about Israel. Teeny tiny country that, by the way, isn't a tyrannical, fascistic dictatorship or a totalitarian government or a failed terror supporting state. It's a pluralistic Western democracy that based on the rule of law and the notion of religious tolerance. By the way, it's not perfect. Neither are we in America perfect. No place where human beings reside and govern can ever be perfect. The point is it better than the alternative? And it certainly is. And so the question to my mind isn't whether it's fair to put Israel on trial. The question to my mind is, now that Israel has been put on trial, can we apply to Israel the laws in a fair and neutral and objective way, unlike what we've seen on the international or global stage? What if the law was applied not in a biased way against Israel, but in a neutral and objective way? What would the result look like there? And that's what the book endeavors to do. So I'm happy to answer your questions about it.
Rory, thank you for that. There's obviously a lot to talk about, and I know I have questions, and I know Alex has questions, and I'm sure our audience as well. But let me start off by saying, I mean, look, I greatly appreciate, and admire the courage you've done, and as far as taking on this issue legally. There's a lot of the lawfare debate is obviously a rich debate that's happening, and we're seeing all these kangaroo courts taking place around the world. And obviously the impact of taking people and judges in particular to Israel to actually see on the ground, to disconnect between the propaganda and the actual reality, and not to mention how the Israeli judiciary works in Israel and what's applied to all of it. But talk about a little bit about the fallacies of this, the game of international law and how it's being applied against Israel, and you correctly talk about evidence and you giving Israel a fair shake legally. But when you talk about institutions such as they are, like the International Court of Justice and the other kind of games that are played out at the United Nations, there's this anchoring within so-called international law. We all know it's a game, but obviously it has credence, within all that. How do you combat that? And from your legal mindset, what's the best way to tackle all of that to ensure the fact that Israel does get a fair shake? Especially, as you mentioned in your earlier remarks, the game, the article, the blood libel that came out of Christoph now. I mean, these are, a perfect example rooted in lack of evidence, yet it doesn't matter.
Yeah, and this is a really important point. I mean, the problem with the ICJ and the ICC is that it purports to function as a court, but it actually is a political body. I mean, the central job of a judge is to put aside bias and prejudice if you can, to put aside any political, partisan, or ideological affiliation you might have if you can, and to render a decision that's based only on the evidence and the law based on whatever the burden of proof in the case happens to be. But the problem with these international courts is that they are the actual nominated representatives of a political entity, a country. Whether it's a democracy or not, that country has geostrategic objectives and obviously is sending its judges as its representatives to decide cases in conformity with those strategic objectives. And so it's not a surprise that a Chinese judge is going to vote against Israel. It's not a surprise that the Lebanese judge is going to vote against Israel. It's just not a surprise that the judges who come from countries that are either allied with America's or Israel's geostrategic enemies are going to vote against Israel time and time again. And it's also important to recognize the way that a lot of voting happens at the United Nations. And actually, Brett Schaefer, a scholar at AEI, has written a great deal about this, and I commend you to his work. A lot of the voting at the United Nations is done by blocks, and those blocks are often continental in their structure. And so the two biggest and most important voting blocks, one would think it would be the United States, given the amount of money we give and how foundational we were to the creation of the United Nations, but that's not true. The most important voting blocs in the United States, just by virtue of size, since it is a democratic body, are the African and Asian blocs because they have the most countries and the most people and therefore the most clout. And if you look at the most important voting interests, if there is a monolithic voting interest within those two most important blocs, Asia and Africa, those are all Muslim countries because Muslim countries, there's 57 of them in the world, constitute a majority of both the Asian and the African bloc. And so what happens is people say, oh, why is the government of South Africa voting against Israel? Why is the government of Nicaragua voting against Israel? And of course, you have to see that these are countries that are deeply tied in with the interests of governments that are very geostrategically misaligned with either Israel or the United States, either because they bear a very close affinity to China or Russia or some of the Muslim states. And so what ends up happening is you either have countries that come to the ICJ with their representative who are beholden to Chinese, for example, interests, or you have countries that come to the ICJ with relatively independent interests, but who are beholden to the Muslim voting bloc in their continent for a variety of separate and independent reasons having nothing to do with Israel. So, for example, imagine that you're from Sierra Leone or whatever, and you've got like a really smart lawyer, doctor, engineer whose career you want to promote through the international court system or promote him to an international medical body or board of some kind. And you've got to do that through your voting bloc at the continental level. And so you're going to go to the countries who really drive the discussion in your continent, whether that's Africa or Asia. That's going to be mostly the Muslim countries, as we discussed. And they're going to say, great, well, we'll be happy to promote this person. We'll be happy to promote your country's interests on the international stage. You just have to, in return, vote with us when we ask you to. And that includes voting with us against Israel when we come to you and tell you to vote against Israel. And of course, Sierra Leone may have absolutely nothing to say about Israel and absolutely no strategic misalignment with Israel. But when it comes time to promoting its own interests, it's going to have to give some to get some. That's the way politics work. And ultimately, that's the way these supposed courts work. And that's why we shouldn't be fooled by treating them as real courts of law and justice in the way that we see and think of courts of justice either in the United States or other Western pluralistic democracies.
Great, thank you. Alex, on to you.
Yes, thank you. Let me follow up on that a little bit. International institutions and by extension international laws are, as you say, politicized instruments of geopolitics and patronage. Why do you think this is not well understood, particularly within the American context, where there is this easy, whereas there is also an easy conflation or a deliberate conflation of law of armed conflict and your international humanitarian law, all under this mushy rubric of international law says this. Where does this come from, in your opinion?
I think there's a couple of reasons. The first and obvious one is that we in America are actually used to trusting our courts. One of the things that polling data consistently shows is that whatever Americans feel about their executive or about the legislative branch, and by the way, there's plummeting support for other institutions in the country, including, for example, universities, as a recent Pew poll, I think, showed. The judiciary is actually reasonably well respected by most Americans because we're not perceived as being either far right or far left or too Republican or too Democrat. We're seen by most people as being neutral arbiters of the most important disputes in our society. I don't say that just because I'm there. That's what the polling data shows. And I should say that I'm very, very close with many of my colleagues as federal judges around the country, both Republican and Democrat, and can confirm for you that although in any group that size, there are going to be people that whose interests are maybe somewhat misaligned, that on the whole, my colleagues are unbelievably devoted patriots, and they're dedicated to the future prosperity of the country and the rule of law. And I think Americans feel that viscerally and have been taught to feel that viscerally for many generations. And so when they think of courts deciding complicated and contested issues, I think they overlay part of their own experience and perception of what courts do, how they operate, and the extent to which they should be trusted onto the supposed court systems that are rendering decisions on the international stage. And as I suggested earlier, that's not necessarily an apples to apples comparison. The second thing about it is that our geostrategic enemies, and by that I mean America's geostrategic enemies, don't really have an incentive in making known just how much they control the political processes that ultimately guide the decision-making at these courts, for the very reason that you describe. It is helpful to them to have people naively in Western democracies, including ours, the most important and most potent Western democracy of them all, believe in the judgments of these courts, because so often those judgments will go against our own interests. And by our interests, I mean the interests of, for example, America, but also our vital allies' interests, like Israel's. Remember that the Chinese government is a geostrategic enemy of the United States. And when they look at their side of the 50-yard line, I've played football, and so it's important to me to use these kinds of analogies. They look at their own 50-yard line, and they see themselves, right? A big army that's never been battle tested, an economy that's shrinking every year vis-a-vis the American economy, and demographic problem that because of the one-child policy, they have to ask themselves, will Chinese mothers be willing to send their only begotten son to conquer an island far, far away? We don't know. And guess who? They don't know. And that's deeply disconcerting to them. A Russian army that was bogged down and shown to be relatively ineffectual against a much smaller and supposedly weaker foe. And then Iran, on the verge of financial collapse, totally isolated, sanctioned, unable to distribute its oil, its S-400 defense systems rendered relatively obsolete by a teeny tiny country thousands of miles away. That's a trouble. That's a problem. And then they look at our side of the 50-yard line and they see, of course, the United States. That's the most powerful army and economy the world has ever known. But who's going to stand with America in the geostrategic conflict that's coming? I don't think they're that afraid of the Belgians or the Irish or the Spaniards. But there are two allies of the United States who have proven themselves not just to be resilient in the face of a general nihilistic invasionary onslaught, but who have proven that they can fight and win the wars of the 21st century against much bigger and supposedly more powerful foes. And those are Israel and the Ukraine. In the law, we always ask ourselves to scrutinize the incentive structures of the people, entities, or governments that are providing us with the information we're relying on. But are we properly scrutinizing the information that's being fed to us through our phones and on the internet and through our news outlets, much of which is coming either through TikTok or through Al Jazeera and its many, many tentacles, through the AP and Reuters, from our geostrategic enemies, China and the Muslim Brotherhood? And we have to ask ourselves, who benefits from the fact that the overwhelming majority of the negative information we see on our phones about our allies in the world, about two other countries in the world? Remember, there's 192 other countries in the world, but most of the misinformation we get on our phones about those 192 countries are only about two countries. And that's about Israel and Ukraine, the two countries that, as I say, are both allies of the United States and have been successfully fighting and winning the wars of the future. Is that a coincidence? Who benefits from that reality? We need to be asking ourselves those questions.
Let me jump on that for a second. Let's go into some of the also the domestic issues. I mean, many of our members live and breathe in higher education and are dealing with a lot of the problems that you're describing. The religiosity, as all of us know when it comes to higher ed, is the religiosity of free speech. Obviously, the debate that's happening today and the case that it's being being argued or trying to be difficult to argue is, again, when it comes to matters of hate speech, and not to mention arguing the case for anti-Semitism and discrimination. And so from your legal standpoint, I mean, what's the best way to tackle some of these issues when it comes to making the cases for the discrimination issues and enforcing those matters? And one step further, obviously, we've seen, a lot of these cases when it comes to some of the foreign funding that, related to student visas and issues that are coming into individuals that have ties to FTOs. And so they're all, some of these cases like Mahmoud Khalil in, Colombia, I mean, took a long time in the way that they're being looked at from a legal standpoint. Insight into that, and better ways to combat this. We have argued, Alex and I, in our writing and other things that we've done, that this is a matter of national security, not a matter of free speech. But obviously, when it gets to the courts, it depends on where, who hears these cases.
So I won't pass on the viability of the lawsuits because I think that would be inappropriate for me to do that since a lot of those cases are pending in front of colleagues and could one day be pending in front of me. I'll only say a couple of things. The first is, we have to be careful as Jews, especially, always to be promoting free speech, and that doesn't mean that we promote everything that has happened on campuses. But Jews have done well in societies that are free and open. That's just the reality. And Jews have done poorly in societies that are closed and that limit intellectual transparency. That also is a historical truism. And so the question really, to my mind, on college campuses comes down less to whether something that was said was hateful about a Jewish person or whether it was offensive. The question, to my mind, is really twofold. One, did the thing that was said cross the line between what's speech and what is not speech? And so there, one of the things that I've had the benefit of seeing in my travels around campuses around the country is that so much of what happens on these campuses and happened after October 7th wasn't speech at all. And I think there's a misconception about that. And when we talk too much about hate speech and anti-Semitism, I think we miss an opportunity to talk about what these kids have really gone through, much of which has little to do with speech. So, I go onto these campuses and people ask me all the time, kids, hey, Judge, how'd you deal with anti-Semitism when you were here? And, initially, flippantly, I always say I was 6'4" and 230 pounds and played football, so there wasn't much anti-Semitism to go around. But the reality is that the things these kids are dealing with isn't the anti-Semitism that existed in our parents' and grandparents' age. We're not talking about smears and what you called hate speech. We're talking about kids at Yale who had frozen water bottles, literally ice blocks, chucked at them as they entered the Chabad. We had kids at Harvard who had other kids, their fellow students, linking arm in arm in order to prevent them from crossing free and open spaces on a campus and to prevent them, as in Nazi Germany, from entering campus buildings and classrooms to be able to study on free and equal terms with their non-Jewish classmates. We're talking about kids at Ivy League schools that I have met who would come back on a daily basis to their dorm rooms and find them defaced with swastikas and other symbols of hate, like Hamas's inverted triangle, red triangle. And then they would go on to their RAs and the people who manage their floors, only to have those supervising adults say, well, you kind of deserve it, right? That's the kind of crossing the line from what's speech that's protected to either trespass, battery, or assault, the kinds of things that are, of course, very much not protected. The second thing is when we treat Jews differently. You said I think you said something like the hallmark or the religiosity, the religious creed of our college campuses is freedom of speech. I think I would push back on that a little bit. One of the problems that we've seen is that speech by Jews has been, and sometimes conservatives have been treated differently historically than speech by others. And when a school has a policy of promoting free speech, that promotion has to be fair and equal to all its various subclasses of people, whether that's based on religion, ethnicity, or anything else. And so when you have a university that has been sued in the past by, for example, conservatives for having suppressed their speech in school and has successfully moved to dismiss those lawsuits on the ground that the university is a private institution that doesn't have to comply with the First Amendment, that's fine, right? If that's true, if it's a private institution and it doesn't have to comply with the First Amendment, that's not my view of how an institution should govern itself, but that's okay. Private institutions can govern themselves as they see fit in some ways, not in all ways. That's what being a private institution in this country sometimes allows you to do. But then when those same private institutions are sued by people who are Jewish, who are claiming, hey, this kind of speech was discriminatory towards me or whatever. And the university responds by saying, hey, we had to allow that speech because we comply fully with the First Amendment. Now you see that there's a real problem because whatever you think about hate speech or the line between speech and illegal conduct, when you use speech as a weapon to discriminate against one people based either on their political views, their religious views, or anything else, then you're discriminating in violation of Title VI. Then you're not just promoting free speech wholesale, you're selecting speech based on its viewpoint. And that really is not allowed when it discriminates against a particular class of people. So those are the two areas where I would say where I think there should be an emphasis, and that is where speech goes beyond speech and becomes conduct that's wrongful. And second, where there's selective speech enforcement depending on the source of the speech, which again can be illegal if that discrimination is based on a protected class, as some of the allegations that have been advanced have suggested. Let me just make an overarching strategic point, since I think you were getting at this. I mean, not to denigrate at all what many of the people who have been promoting the rights of Jewish students have suggested. I'm not sure that complaining about speech and anti-Semitism in this way is ultimately a winning strategy in the American landscape as it exists today, for a variety of reasons. On, I think, the ideological left, a Jew complaining about anything is really perceived as hollow. They believe that Jews are what they call white oppressors, and it sounds to them almost like a billionaire heiress complaining about the air conditioning being on just a little bit too low. And on the other side of the landscape, on the political right or the ideological right, there's been an emphasis on moving away from what they view as oversensitivity to speech that people find offensive or that people don't like, to ideological preferences that sometimes touch nerves that maybe people, again, are sensitive about. And so to people on the ideological right, I think there's something tired and somewhat antiquated and maybe even anachronistic about people complaining these days about speech they find offensive or wrongful. That's not to say, again, that in the kinds of speech I described before, the two kinds, one where speech moves beyond speech and into wrongful conduct, and two where speech is selectively employed, speech codes are selectively employed to discriminate against Jewish students, that those two, I think, real deficiencies should be highlighted. I just think that that there's more to the story than complaining. And I think one of the benefits of being a Zionist, one of the reasons I think that Zionism is being abhorred and calumniated in the public discourse in Western civilization is because Zionists don't complain, right? Zionists don't whine. Zionists don't play the victim card. Zionists fight back. Zionists are resilient. Zionists are strong. And I think there's a great deal of resentment about that in much of the Western discourse.
Let me be clear. I mean, I'm with you. I mean, I think that the argument I was getting at was that the free speech is only for some, not for all. I mean, in the way that's been, in the way it's been played out, not to mention engineered when it comes to the narrative of cancel culture, what's been accepted on American college campuses and what's not, which is what many of us have seen and have experienced ourselves and have been canceled and whatnot as we deal with these issues and the way that all this has been parachuted, despite the fact that the institutions themselves claim to have this fervent, belief in the principles of free speech and its importance and whatnot.
Correct.
Practice that has not always come to bear. I mean, and that's been
Correct.
part of the challenge.
I agree
Alex?
with that.
Yeah.
Let me move this away from speech to to action. And as we're sitting here, I can think of at least four examples. The University of Washington, where pro-Hamas demonstrators occupied a building and vandalized it, causing $1 million or $2 worth of damage. Prosecutors ultimately declined to press charges, and the university, after a temporary suspension, restored the status of the students. UCLA, where the institution took the side of the protesters who barricaded part of campus and restricted access. Um, Columbia, where the building was occupied, it was cleared by the police. The university ultimately decided against pressing charges, which were dropped by the Manhattan prosecutor. In any case, time and time again, we've seen simply the refusal of both the universities and also civil authorities, local authorities and state authorities, examples in Michigan as well, to enforce any sort of accountability, including for outright vandalism, property damage. What what should what should we think about this? And what should the action is there recourse on the part of the Jewish community, but also the federal government
So again,
with
I
limited
just don't think,
resources?
yeah, I just don't think it's appropriate for me to pass on any of
Not the
that.
individual cases, but
Yeah,
in general.
I'll just say more broadly that in the context of a university's administration of its own policies, I think, you know, the people like who have been really at the forefront of this movement, like Daniel Diermeyer at Vanderbilt and Andrew Martin at WashU, and even here in Florida, but our local institutions, especially, you know, Ben Sass at Florida and here Joe Echevarria at the University of Miami. I think the way to look at it is the university has to follow three steps. And that is, first, it has to set clear guidelines. Second, these are an articulated set of principles, whatever they are. I suggested earlier that two important principles are: one, that we believe in the freedom of speech, but not the freedom to engage in illegal conduct. And second, that speech means speech for all viewpoints, irrespective of whether we find them offensive, and certainly irrespective of who the viewpoint is coming from, whether that's a Jew, a non-Jew, a conservative, a liberal, etc. So that's the first step, articulating a clear set of principles. A second step is to create clear, transparent rules by which those principles are to be enacted. And third, and most importantly, and I think to get to your point, Alex, the one that has proven, I think, most complicated is when those rules are violated, as they probably were in the instances that you're describing, that a university has to follow through and punish the rule violators, or else the rules just simply will not be followed in the future. That's what we see in societies that don't punish misconduct. That's what we see in political echelons where corruption is not properly criminalized, in like my home country, Venezuela, for example. And it's what we see on university campuses where rioting and trespass and other crimes like assault and battery are not properly disincentivized. So without passing at all on those individual situations, I think that would just generally be my view of how a university should conduct itself.
Going back right to the book, which is obviously what led you to all of this, you know, journey and everything you're doing. Of all the the six criticisms or interrogations that you've done as far as looking at the claims against Israel, are you able to prioritize, I guess from easier to harder to basically unpack or to dispute or to basically, to tackle as far as which one of these cases, is or in the same vein, which ones are easier to tackle in the sense of winning the debate, legally speaking, or are they all equally egregious? What's the best way to kind of look at some of the ways that you've categorized them, beyond that these are the more nefarious ones and the more pervasive ones?
Yeah, I think all six claims are, as I think the book makes clear, completely frivolous. There are some that I think it takes a shorter amount of time to explain why they're frivolous, but each is frivolous. I think it can be summarized in a relatively short period of time. The first claim that Jews are colonists in the land of Israel is frivolous because the Jews are the indigenous people of the land, and no other example of colonization in human history has ever included a people with an ancient lineage of governance in that land as the colonizing power. So to take two very obvious examples of colonization, the settler colonists of the Americas, the English, there's obviously no ancient lineage of English kings and queens who practiced Christianity and spoke English and named their children with English naming conventions like John and George and Thomas. thousands of years ago in Virginia and North Carolina and New York. There's obviously no ancient lineage of Spanish kings and queens who practiced Catholicism and spoke Spanish and gave their kids names like Simón Bolívar in Peru or Colombia or Mexico. But there is, according to the neutral, objective, independent evidence, like rocks in the ground, archaeological evidence, words on the page, documentary proof going back thousands of years, and blood in the veins, DNA proof on all the major Jewish populations of the world. All three buckets confirm that the people who lived in the land between the Jordan River and the Mediterranean Sea going back thousands of years, and who often governed that land, certainly thousands of years ago, are the Jewish people who spoke Hebrew and practiced the Jewish religion, and who passed on to their children the same naming conventions that Jews still use in the land of Israel and around the diaspora today. Names like Eliyahu and Menashe and Asher, etc. The second claim that I tackle in the book is that, and so by the way, just to close a loop on it, Jews can't be colonists in their own land because Jews are the indigenous people of the land. In fact, if you look at the first stone mentioning the land of Israel, which comes from Egypt 3,200 years ago, the Merneptah Stele from 1205 BC, and you look at all the different peoples that existed in the world at that time, and you fast forward until today, there is only one people on earth who still speaks the same language, still practices the same religion, and still lives and governs in the same land as they did 3,200 years ago. And those are the Jews who live and govern the modern state of Israel. So if we care at all about the rights of indigenous people, if we care at all about decolonization struggles, we should recognize that the great decolonization struggle of the 20th century is the reclaiming of ancient Jewish sovereignty over their ancestral homeland. So Jews can't be colonists because a man cannot trespass into his own home. The second claim I tackle in the book is the claim that the creation of the state of Israel in 1948 is illegitimate, and that Israel is thus an illegitimate state even today. The problem with that is that international law sets out a clear four-factor test called the Montevideo Convention from 1933 for determining whether a nation has legitimately become a state. And those four factors are: one, does it have a defined population? Two, does it have defined borders? Three, does it have the capacity of engaging in foreign relations? And four, does it have a single effective government? And there's no dispute that Israel has met all four elements since 1948, and every second of every day since 1948 until today. Interestingly, the supposed state of Palestine, recognized by over 140 countries in the world, indisputably fails two of those internationally recognized four elements. First of all, it doesn't have defined borders, and none of the recent countries that have recognized the Palestinian state in 2025 were willing to tell us what those borders might be, because they know that they cannot and do not want to do so. Second, even if they did have defined borders, the Palestinians aren't governed by a single entity, much less an effective one. Gaza is split in two. About 40% is governed by Hamas, an internationally recognized terror organization that none of the recent countries to recognize a Palestinian state would ever see as the legitimate ruler of the Palestinians. And the other 60% or so is ruled by the Israelis, who no one believes is the legitimate ruler of the Palestinian people. Judea and Samaria, the West Bank, same thing, divided in two. Some of it is ruled by the same Israelis that nobody wants to see in charge. And the other is ruled by the Palestinian Authority, a corrupt, ineffectual, and unpopular government that the Palestinians themselves have told us in poll after survey after survey they do not view as the legitimate government of the Palestinians. So far from being governed by a single government, the Palestinians are ruled by three separate governments most people would not view as legitimate. The third claim about Israel is that Israel prevented the establishment of a Palestinian state. But the problem is that there is a Palestinian state. It's called Jordan. The British Mandate of Palestine encompassed the land that encompasses today both Israel and Jordan. And the Jewish Yishuv believed that in 1917, after the Balfour Declaration, they would be entitled to all of that land. But in the 1920s, recognizing how important oil and Arab interests would be to their future prospects in another world war, the British government split off 77% of the landmass of British Palestine for the Arab Muslims of Palestine, a Palestinian state then called Transjordan, because it was on the other side of the Jordan River, later called the Kingdom of Jordan, and today known as Jordan. But second, and more importantly, Israel and the Western community have offered the Palestinians their own state on 6 separate occasions: 1936 with the Peel Commission, 1947 with the Partition Plan, 1967 in Khartoum after the Six-Day War, where the Israelis came and said, look, we don't want these lands. You take them back, form your own state there, make them part of Jordan and Egypt, whatever you want, just recognize our right to exist. The Arab states got together in Khartoum in September of 67 and came back and said the 3 no's: no peace with Israel, no negotiations with Israel, no recognition of Israel's right to exist. 1993 to 95, the Oslo Accords, an opportunity for Israel and the Palestinians to come to a phased peace process that over 5 years, if the Palestinians met certain requirements, would ultimately culminate in the creation of a Palestinian state, which the Palestinian people reacted to by engaging in an intifada that killed over 1,000 innocent Israeli civilians in bus bombings, pizza parlors, weddings, and bar mitzvahs. Then, of course, in 2000, the most obvious failure of all, where Bill Clinton offered the Palestinians, together with consent from Israel, just almost all of the land the Palestinians now claim and their supporters now claim they desire for a Palestinian state, including half of Jerusalem, an offer that will never be on the table again. And Yasser Arafat rejected it. And then again, the same rejection in 2008. The Palestinians rejected each of these 6 offers, not because they want to coexist with Israelis in a peaceful 2-state solution, but because they've always insisted, as they do today, as my book shows, in poll after poll after poll, they insist on only one state from the Jordan River to the Mediterranean state and to the Mediterranean Sea, a state that's fully Arab and with no Jews on it. So that's the third main claim. The fourth claim is that Israel had turned Gaza into a Palestinian state, into a Palestinian open-air prison or concentration camp. Unfortunately, I know all too well what prisons are like, and my family went to the concentration camps, so I've heard from them about what those concentration camps were like. And the central feature of a prison or concentration camp, of course, is the prisoners have to ask the warden for permission to do anything, and that they aren't free to leave because the warden's job is to keep them there. But the problem with the open-air prison and concentration camp myth is that, of course, Israel has always insisted that Gazans who want to leave should be allowed to leave, and that the only reason Gazans were forced to remain in harm's way during the war in Gaza is because the Gazans' supposed allies, including, of course, their governing structure, Hamas, many of the local Arab states, and of course the European countries, insisted that Gazans were forced to remain inside of Gaza during the war, irrespective of the fact that the supposed warden was insisting that they should be free to leave, not consistent with any prison or concentration camp I have ever heard of. And then the last 2 claims, which I'll summarize quickly, are the 5th claim that Israel is an apartheid state, and the 6th claim that Israel perpetrated a genocide in Gaza.
Thank you for that. Then obviously those are, the low-hanging fruit. Then obviously, clearly issues that need to be that come up again in every way, shape, or form through every medium of the media that we see today, as far as those allegations. I mean, I think that's the critical part. And obviously, the thing that we deal with all the time is, of course, the lack of context or historical knowledge to any of these claims. That continues to be the guiding rule, and the facts don't matter, don't confuse me with the facts, is something that we see all the time because everything is then boiled down to a meme or an emoji to try to encapsulate, history as you explained it properly all along. Alex, I'm going to give you, just keeping an eye on the time and knowing that Roy is tight on time to his next interview
Right.
and requirements. I'm going to give you the last question and then we will, unfortunately wrap it up, but hopefully come back later on, Roy, and talk about more discoveries along the way.
Right. Can we move this very briefly to a different cultural context and a different trust in, you spoke about trust in institutions and trust in legal institutions in particular, which is a hallmark of the American system, really, American culture. This is very much not the case in Europe, where the situation is, to my mind at least, a kind of fetish of human rights. Again, a mushy, nebulous concept which includes lots and lots of things. Is there a fundamental conflict between European conceptions of human rights, including as how they are expressed legally, ultimately through institutions like the European Court of Human Rights, and American concepts of human rights?
Well, I mean, I think there's just a problem of legitimacy, and you're seeing that now with some of the objections that we get from Hungary and Poland, and even in the UK at the time of the Brexit vote, the question whether an international court that is not representative of the democratic mores of the people that comprise the countries that are being governed by that court, whether that court should be entitled under some very, very, very broad interpretation of a statute that ultimately was just a few lines, just to protect human rights, that based only on that sort of very amorphous and somewhat ambiguous and open-ended phrase, should be entitled to invalidate, strike down the democratically enacted and fully promulgated laws of democratic societies. That's very problematic. I mean, we deal with this here in the United States, right, where since the founding, or at least since 1803, in the case of Marbury versus Madison, one of the controversial aspects of the federal judiciary here has been what we call the power of judicial review, the power that each federal judge has to strike down, to invalidate, to declare unconstitutional the actions of the two political branches, whether that's the president elected by all the people or the legislature elected by all of the people in constituent assembly. And the issue was resolved in a way by insisting that the process of judicial review in America not be anti-democratic as it sounds. On first blush, you say to yourself, well, here's an unelected judge, not representative of the moral will of the people, because nobody put him there. How is he going to invalidate the moral will of the people as promulgated through the acts of their duly elected representatives? Well, we've solved that problem, we think, in two ways. One, we insist that the other two branches of our government, remember we have three branches, that the other two branches of our government, the executive and the legislative, be the ones to put the judge in power, right? We want to make sure that if a judge is going to be there for life, as we are, and if they're going to have this extraordinary power to invalidate the moral will of the people, that those judges have been handpicked by the political branches themselves. So that's one. And that's in the first instance, or ex ante. And second, and maybe more significantly, that the judge can only invalidate the democratically enacted norms of the people by reference to a super legislative, extra constitutional document. And that document is a super majoritarian framework, which we call the Constitution. And we believe it to be able to bind us for all time for two reasons. One is that the Constitution was passed by super majorities, not mere regular majorities. So as you probably know, that under the Constitution, the Constitution and each constitutional amendment must be passed either with a vote of 2/3 or 3/4. And it must do so also by combining support both at the federal level and through the states, either by state constitutional conventions or through the legislatures. But second, and just as importantly, when we vote for a representative to go represent us in Congress, we send the person there. We don't vote for a particular issue. We send Representative X to go make decisions on our behalf in the Congress from Virginia or from Florida or wherever you are. But when we vote for delegates to a constitutional convention, the constitutional text is itself the thing that's on the table. And the people who run to be the delegate either say they're for it or against it, and that's the only issue they're going to vote on. And so the people really are engaging in a very popular referendum on whether the provisions of that constitutional system, whether it's an amendment or the Constitution itself, should be promulgated or not. And so for those two reasons, we believe that the Constitution should bind future generations of Americans over and above what we see as the transient or ephemeral will of the people today. So that's why, for example, if 100% of the people of, say, Virginia voted to have a law that said that blacks could not marry whites, right? And there was such a law. Then it would be permissible, we think, and democratic, not anti-democratic, for the Supreme Court to strike the law down because the Constitution, passed by super convention delegates in super majoritarian conventions, the Constitution says you can't have that kind of law. You have to have equal protection of the rights of citizens between the races, right? And so, so those two democratic norms that we've imposed, overlaid on the judiciary, we believe have kind of solved the once intractable problem of judicial review, so that now in America, we see the judiciary not as anti-majoritarian or counter-democratic. We see it rather as super-majoritarian and super-democratic. In Europe, though, where the statute is extremely open-ended, the human rights law, and where the judges aren't being placed there necessarily by the political branches, I think the problem is a much deeper one. And I think a lot of the objections that you're seeing from some of these countries to the judges acting in an undemocratic or counter-majoritarian way are probably things that we in the United States would never stomach because of our democratic history and pedigree.
Right.
A republic, if we can keep it.
If we can keep it.
Indeed.
Exactly. Roy, I want to thank you for the rich and for the erudite conversation. It's been great to have the conversation. Obviously, there's a lot to unpack here, and thank you for all you're doing. Obviously, I recommend to everybody, our audience, to go out and read your book. There is much to read, and it's a good book to add to our toolbox as we're looking at these issues. So again, thank you for taking the time to talk to us. Thank you, Alex, for joining me as always. Thank you, everybody who came to join us this afternoon. Be on the lookout for future webinars that will be coming out in the next day or so. And we look forward to talking soon.
Thank you both.
Thanks very much.